Bath Rugby Ltd and Greenwood and others.
Please your ladyship and your lordships, I appear for Bath Rugby Ltd. My learned friends, Mr. Hutchins QC and Miss Holmes, appear for Bath Recreation Ltd. And my learned friend Mr. Moffat appears for the 7th and 8th respondents, 77 Great Pulteney Street Ltd. And Mr. White. As the court will have seen, this appeal concerns the interpretation and effect of a 1922 conveyance of playing fields in Bath known as the Rec. The issue is whether two nuisance covenants imposed by that conveyance are enforceable by anyone today, and the appellant's case is that those covenants are enforceable by no one because the benefit of the covenants is not annexed to any land. Now, as the court will appreciate, that does not, if we're right about that, that does not mean that my client as the lessee of part of the Rec will necessarily be able to carry out its proposed development of replacing its outdated stadium with a new modern stadium. If we succeed on this appeal, we will need planning permission, and whether planning permission is granted will depend upon whether the planning authority is satisfied that the stadium is in the overall public interest, having regard, amongst other things, to the impact of the stadium on the amenity of that part of Bath. Without further ado, if I could take the court to the transcribed version of the 1922 conveyance, which you'll find in the supplemental, the supplemental bundle at page 236 and 237. Now, for our purposes, there are three relevant parts of this conveyance. The first relevant part of the conveyance is the recitals. Now, I'll let the court read through the recitals, but they start at page, about line 8 of the document. But essentially, the recitals explain that the Rec forms part of the Bathwick estate, that the Bathwick estate is subject to a settlement, that Captain Forrester was the tenant for life of that settlement, and it was in that capacity that Captain Forrester was selling the Rec. The second relevant part of the conveyance is over the page, 8 lines down, which is a drainage easement. So the conveyance provides, except and reserving unto the vendor and his successors in title, his heirs, his and their heirs and assigns, the free and uninterrupted passage and running of water and soil from the other buildings and land of the vendor and his tenants adjoining or near to the said hereditaments hereinbefore described, through the sewers, drains, and watercourses which are now, or may hereafter be, in or under the said premises. It's a drainage easement. And the third relevant part of the conveyance is clause 2, which imposes 3 restrictive covenants. And you'll see it provides that the purchasers for themselves, their successors and assigns, hereby covenant with the vendor his successors in title and assigns, and to the intent and so that this covenant shall run with and be binding on such portions of the hereditaments and premises hereby conveyed as are respectively affected thereby into whosoever hands the same may come, but so that the purchaser shall not be personally liable in damages for any breach thereof after they shall have parted with the same hereditaments and premises. And then we arrive at the first covenant, that no workshops, warehouses, factories or other buildings for the purpose of any trade or business which may be or grow to be a nuisance, annoyance, or disturbance, or otherwise prejudicially affect the adjoining premises or neighbourhood, the neighbourhood shall at any time hereafter be erected upon the said hereditaments and premises, except the part now in the occupation of Artcraft Limited. And then we find a second nuisance covenant, and that nothing shall be hereafter erected, placed, built, or done upon the said hereditaments and premises, including such part thereof as last of first said, as shall be or grow to be a nuisance, annoyance, or disturbance, or otherwise prejudicially affect the adjoining premises or the neighbourhood. Then we come to the third covenant, which is an absolute covenant, provided always that no factory chimney shall be erected on the portion of the said hereditaments now in the occupation of Artcraft Limited. And a point I make about the nuisance covenants are common in leases and amongst freehold covenants, and these covenants are exceptionally restrictive. They are breached if there is, in any of the stipulated ways which are broadly defined, if there's any prejudicial effect on, amongst other things, adjoining premises. So whilst nuisance covenants are common, these two nuisance covenants are exceptionally restrictive. Now, turning first to His Honour Judge Paul Matthews' reasons for thinking that the conveyance does annex the benefit of those nuisance covenants to some land. So you'll have seen that he thought the benefited land for the purposes of the covenants was the dominant land under the drainage easements. And so perhaps keeping open the conveyance, if you could turn to the core bundle starting at page 127. So first of all, paragraph 61 of the judgment, the learned judge correctly said this. He said it's not enough to demonstrate an intention to benefit land. It is also necessary to identify the land intended to be benefited. Turning over the page, the learned judge seems to have accepted, as we read the judgment, that the benefited land has to be clearly identified. And we say that because paragraphs 65 and 66, the learned judge refers to the Newton Abbot Cooperative Society case. And at paragraph 66, he quotes a passage from Mr. Justice Upjohn's judgment, where he says, in this difficult branch of the law, one thing in my judgment is clear, namely that in order to annex the benefit of a restricted covenant to land so that it runs with the land without express assignment on a subsequent assignment of the land for the benefit of which it is taken must be clearly identified in the conveyance creating the covenant. Now, the judge's reasons for saying that the conveyance does annex, or did annex, the benefit of the covenants to land are conveniently contained in a single paragraph at page 137, paragraph 96. I'd invite the court to read that paragraph. So if we could look back at the conveyance at page 237 of the supplemental bundle, there were two steps to the judge's reasoning. The first step was to say that in substance, I'm not sure what in substance was meant to add, but he said in substance the nuisance covenants were for the benefit of the adjoining premises or the neighbourhood, as that phrase appears twice in clause 2. And the second stage of the judge's reasoning was to say that the phrase, as it appears in clause 2, the adjoining premises or the neighbourhood, means the same thing as the description of the dominant land of the drainage easement in clause 1, namely the other buildings and land of the vendor and his tenants adjoining or near to the wreck. So, as a result of those two steps, the learned judge thought that the benefited land for the purposes of the covenants is identified in the conveyance by the description of the dominant land in the drainage easement. Now, in my submission, both of those two steps of the argument is obviously wrong. The first step is wrong because the reference in clause 2 to the adjoining premises or the neighbourhood, rather than purporting to identify any land to which the benefit of the covenants might be annexed, is obviously simply part of the explanation of what constitutes a breach of covenant. It is by reference to the impact of various specified things on the adjoining premises or the neighbourhood that you can work out whether the covenants have been breached. Now, by using the concept of the neighbourhood in that way, the drafter of this conveyance was adopting a common way of framing nuisance covenants. It has always been the case that nuisance covenants, whether tenant nuisance covenants in leases or freehold nuisance covenants, it's always been the case that they often identify what constitutes a breach of covenant by reference to its impact on the neighbourhood. And it's understandable. I mean, imagine if you're a landlord. You can well understand why a landlord might think it helpful, for the purposes of protecting its reversionary interest in the demised premises, to prohibit their tenant from causing a nuisance to the neighbourhood. A landlord will, some landlords think that one way or another, if a tenant harms the neighbourhood, that will come back to harm them in their capacity as the reversion of the demised premises. So equally, in a freehold context, if a vendor of land retains some land, vendors of land sometimes think it's helpful, again for the protection of some or all of their retained land, to prohibit the purchaser from causing a nuisance to the neighbourhood. If you're the owner of some freehold land, you think it might well be in your interest that your neighbour, as the owner of some neighbouring freehold land, is prohibited by covenant from causing a nuisance to the neighbourhood. Because as the owner of freehold land, you're one way or another might well be harmed by some nuisance to the neighbourhood. Because, after all, you're part of the neighbourhood. So, whilst the concept of the neighbourhood is perfectly well suited for that task of helping to explain what constitutes a breach of a nuisance covenant, it is wholly inapt for the purpose of identifying the land to which the benefit of a covenant is annexed. And there are two reasons for that. The first one is, I'd submit, just unanswerable. You've got to remember the benefit of a covenant can be annexed only to land owned by the covenantee. But the neighbourhood, whilst it might include properties owned by the covenantee, will also include properties owned by lots of other people. So it just cannot be used for the purposes of identifying the land to which the benefit of a covenant is annexed. There's also another point, which is that that point is, I submit just absolutely no answer to that, but there is another point, which is the concept of a neighbourhood does not refer to any particular properties. It's just how the concept works. If I say something about the local neighbourhood, I'm talking about something of an indefinite geographical area. And part of the reason might be the idea of a neighbourhood as a kind of social aspect. It means something like a geographically located community.
Are there any authorities on
Yes.
how extensive a neighbourhood is for the purposes of nuisance covenants?
We've got 5 authorities in the bundle dealing with this. Can I just finish off this submission and then I will refer to, including, there is a Court of Appeal case which suggests that exactly what I've said, that the concept of neighbourhood can't be used to define benefited land because it's too uncertain. But if I could just finish off this point before I get to the authorities.
Yes.
So, this contrasts to the expressions that are used to identify the land to which the benefit of covenants are annexed. Expressions like adjoining properties, properties near to the burden land, neighbouring properties, retained land, now all of those expressions refer to particular properties. It might be hard for a court to identify the precise properties to which such expressions refer, but if push came to a shove, a court would have to do that. And these are expressions that refer to particular properties. Now, as I say, that contrasts with the use of the concept of a neighbourhood. So, to answer my Lord Justice Nugee's point about authorities, I could first of all make this point, that whilst, as I said earlier, conveyances have always deployed the concept of a neighbourhood to explain what constitutes a breach of a nuisance covenant, they've never used the concept of a neighbourhood to identify land to which the benefit of a covenant is annexed. Never. In the bundle of authorities, there are 5 examples of cases where the concept of a neighbourhood has been used by the drafter to explain what constitutes a breach of the nuisance covenant by saying you can't do all these things if they harm the neighbourhood. In none of which was the concept used to identify the land to which the covenant was annexed. I don't propose to take you to, I only propose to take you to one of those authorities, but if I could give you the references, just so you can see how in practice drafters have used the concept of a neighbourhood in restricted covenants. So the references are Divider 5, page 540. As I say, I needn't take you to all of this. Maybe you could just make a note of the first four. It's Divider 5, page 540, and that was a case where there was no retained land. Divider 9, page 617. Divider 19, page 1. That was a tenant covenant in a lease. And Divider 36, paragraphs, I think it's 6 and 8. Certainly 8. The most important of the cases on the use of the neighbourhood for the purposes of any suggestion that they can identify the benefited land is the authority at Divider 13, which I would like to take you to, Marquess of Zetland and Dryden. Now, this is an important Court of Appeal authority on covenants, and it's also it's an important case in relation to the issue about whether the land has to be easily ascertainable. So in the course of going through this authority, I'll also take you to the relevant parts of the judgment of the judgment of the court in relation to that issue. So in this case, the Marquess of Zetland was the tenant for life of an estate in Redcar. In 1928, he sold a parcel of land situated on the estate to be used to build a shop and a dwelling house. You imagine perhaps a ground floor shop and a flat above. And the conveyance contained a nuisance covenant, and we see that at the foot of page 2 of the report. So there we are. It says, this is about 6 lines up. The purchaser, to the intent and so as to bind as far as practicable the said property hereby conveyed, into whosoever hands the same may come, and to benefit and protect such part or parts of the lands in the borough, township or parish of Redcar in the North Riding of the County of Yorkshire, now subject to the settlement, as shall for the time being remain unsold, or as shall be sold by the vendor or his successors in title, with the express benefit of this covenant, covenants with the vendor and the purchaser at all times to observe the covenants in the second schedule. And we see the last 5 sentences of that paragraph. One of the covenants was to do no act or thing shall be done or permitted thereon, which in the opinion of the vendor may be a public or a private nuisance or prejudicial or detrimental to the vendor and the owners or occupiers of any adjoining property or to the neighbourhood. So just a few things I want to say about this. First of all, it looks, from the description at the top of the page, it looks like the covenant has very clearly identified the land to which the benefit of the covenant was annexed. Really doesn't seem as if it could have been clearer. The nuisance covenant, part of it is similar to the nuisance covenants in our case. We've got adjoining premises or to the neighbourhood. This is adjoining property. But I would point out, for the purposes of what the court said, that, as I emphasised a moment ago, there has to be a detriment both to the vendor and to the owners or occupiers of any adjoining property or the neighbourhood. Now, what happened was that the purchaser's successor in title opened a fish and chip shop, and the Marquess of Zetland's successor in title, the new tenant for life under the settlement. And then we see this at the page 4, first about 5 lines down. So the new Marquess of Zetland formed the opinion that such sales were detrimental to the amenities of the neighbourhood and to his own property. And then towards the foot of that paragraph, last 7 lines, the parties agreed that the lands for the benefit of which the covenant was taken included a small portion of land contiguous to 200 Lordship, the Burn land, a number of scattered parcels of land to the north and west with houses built on them, and to the south beyond a large area covered with buildings, certain land, part of which was more than a mile away. Now, strangely, for reasons which don't appear from the report, at first instance, Mr. Justice Bennett thought that the covenant, the benefit of the covenant, hadn't been annexed to any land, despite what the parties had agreed. And it's difficult, it's impossible from the report to understand that. So in the Court of Appeal, the owner of the fish and chip shop said, first of all, the judge was right in saying that the benefit of the covenant hadn't been annexed, and also said there was no breach. And one of the submissions that counsel for the fish and chip shop owner made, you'll see at the top of page 6, second line, it was argued that the covenant is too vague and uncertain to be enforced. As I said, there was a judgment of the court, and first of all, page 8, the court set out the principles that are applicable to determine whether the benefit of a covenant has been annexed to any land. There's page 8, and the principles are set out in the paragraph starting, such covenants can only be validly imposed. And for our purposes, it's important to see that the third of the principles, thirdly, halfway down the paragraph, the land which is intended to be benefit must be so defined as to be easily ascertainable. And the fact that the covenant is imposed for the benefit of that particular land should be stated in the conveyance and the persons or class of persons entitled to enforce it. And then 7 lines up from the foot of the page, applying those principles to the present case, the covenant sued upon appears to comply with them. The covenant's restrictive. It's expressly stated in the conveyance to be for the benefit of the unsold part of the land comprised in the settlement, and such land is easily ascertainable. And that's an important sentence on the easily ascertainable test, because the court is clearly treating, it clearly thinks there's 2 requirements here. First of all, that the conveyance identifies the benefited land, but also there's a separate requirement that such land is easily ascertainable. Nor is it suggested that the date of the conveyance of land retained was not capable of being benefited. So over the page we come on to the question of whether the covenant was too uncertain. And its first full paragraph, it is said, however, on behalf of the respondents, that this covenant is not one which can run with the land because it is imposed for the benefit not only of the unsold land of the vendor, but also for the benefit of the adjoining owners and the neighbourhood. I mean, pausing there, we don't know what that argument was exactly, but presumably it was the argument I'm advancing now. The neighbourhood is, forgetting about the adjoining owners, the neighbourhood is inapt because it includes land not owned by the vendor, and also because it doesn't refer to particular properties. Court went on, if that were the true construction of the covenant, that might be so. But in our judgment, reading the covenant as a whole, it cannot be so construed. Now, so the court there is making the point that when the covenant comes to talk about what constitutes a breach, there has to be a nuisance not only to the vendor, but also not only to the adjoining properties and neighbourhood, but also the vendor. the court's making that point. But there is a wider point the court could have made, which is that, as I said earlier, there is nothing impossible or unconventional for the benefit of the covenant to be attached to a particular piece of land, but where the breach occurs as a result of harm to the wider neighbourhood. And we see that in the cases, the other authorities which I gave you the reference to. You see that in leasehold covenants, tenant covenants, nuisance covenants, and also regularly in freehold covenants. So if we could again go back to looking again at the conveyance. So both steps of the learned judge's reasoning were obviously wrong. So that, I think I've hopefully dealt with the first step, which is that the adjoining premises or the neighbourhood is obviously performing the task of telling you what constitutes a breach of covenant, is not purporting to identify the benefiting land, nor could it. So then we come to the second stage of the learned judge's argument, which is that the expression in clause 2, the adjoining premises or neighbourhood, means the same thing as the other buildings and land of the vendor and his tenants adjoining or near to the said hereditaments hereinbefore described in clause 1. Well, I mean, that's obviously not right. In multiple respects, those phrases describe different things. The two big differences are that, unlike buildings and land of the vendor and his tenants adjoining or near to the wreck in clause 1, the adjoining premises or neighbourhood in clause 2 is not confined to premises owned by the vendor. Another big difference is that the reference in clause 1 to the premises near to the wreck, as it appears in clause 1, does not mean the same thing as the neighbourhood in clause 2. These are just they refer to totally different things. And I'd also make the point that there is no earthly reason why the dominant land under a drainage easement and any land to which the benefit of the covenants was annexed should be the same. These are covenants, these are the drainage easement and the covenant provision. They're just doing totally different things. So the dominant land under the drainage easement was bound to be something like what we see in clause 1, namely other buildings and land of the vendor and his tenants adjoining or near to the wreck. That's what you'd expect. In contrast, when you come to the covenants, given that the vendor owned property spread over 600 acres and the covenant included causing prejudice to the neighbourhood, there is no reason to think that the any land to which the benefit of the covenant was annexed should be confined to land, buildings and land adjoining or near to the wreck.
What was the 600-acre figure?
So the properties owned by the vendor are located over an area of 600 acres, and I get that from the auction particulars of a 1919 auction, you'll see it at page 70. So there was an attempt to sell the entirety of the Bathwick estate by auction in 1919. These are the auction particulars. And there was an attempt in 1921 to sell in lots part of it, which resulted in some sales. But you can see from here that the Bathwick estate was situated over an area of 600 acres. And in fact, there's probably no need to look at it now, but if you're interested in the auction particular plan is in the plastic folder at the front of this bundle. But this is a document that also has perhaps some relevance when you're thinking about what the Bathwick estate is. I mean, what is the Bathwick estate? It's this group of houses, shops, hotels that were owned by the Pulteney family.
So is this what you say, that there is no reason to think that the Captain Forrester would have wanted the benefit of any covenant to be confined to the particular bits of the estate that might possibly benefit from drainage? Even if he hadn't intended to encompass the whole estate, it would be irrational to think that he would have...
totally different things.
Yes.
Especially when you bear in mind the big area over which the estate was situated, and the terms of the covenant, which includes not harming the neighbourhood.
Do we know how much of it was unsold in 1922 at the time of the conveyance?
So I'm planning to address you on that when I come on to the easily ascertainable question. I can't give you a very short answer, so I wonder if I can delay answering that question until then. But the answer is no.
I thought you said it was going to be a long answer.
I can give you a short answer.
I think
I can't give you a short explanation of why the answer is correct.
But I mean, we've gathered from the papers in any event that some was sold, but a lot remained unsold.
That's right. Yeah, that's right. 1921 is only part of the estate, and from newspaper articles you can see that some properties were sold. Just going back to the conveyance, page 237. So just finishing off that point, it was an unnatural and really odd interpretation of the conveyance to find the benefited land for the purposes of the covenants described in an entirely unrelated provision reserving a drainage easement. But just there is also another point, which is that so the judge thinks that the benefited land is, for the nuisance covenants, is the adjoining premises of the neighbourhood. But there is a third covenant. That's the absolute prohibition on constructing a factory chimney on part of the land. So the judge's reasoning doesn't explain how you're meant to figure out what land the benefit of that covenant is annexed. So, for those reasons, the judge's reasoning is from beginning to end completely wrong. There is no respondent's notice. There's no suggestion that the outcome in this case should be supported for any reasons other than those provided by the judge. But I would like to address the court on this, because the judge was very influenced by the reference to successors in title in clause 2. Despite the absence of response notes, I would like to address you on that. So the judge's thinking is that the reference to successors in title plainly meant that the parties intended the benefit of the covenants to be annexed to some land, saying that people who own the same estate as the vendor will be able to enforce the covenant. And then the judge thinks he has to try and find in the conveyance some land which might be the benefited land, which why, through this very strained, incorrect reasoning, he ends up at the dominant tenement. Now, my learned friend Mr. Hutchins QC will address you on whether the learned judge was right to infer from the reference to successors in title an intention that the benefit of the covenant should be annexed to some land. But for the purpose of my argument, let's accept that the reference to successor in title does disclose an intention that the benefit of the covenant should be annexed, would be annexed to some land. Let's assume that. Nevertheless, even if you accept that, that does not help the respondents, which presumably explains the absence of a respondent's notice, but for two reasons. First of all, there is a separate requirement. You don't have to establish only an intention that the benefit of the covenants be annexed to some land. You also have to establish that the benefit, that land is clearly identified. Now, I'd simply say this about that in the absence of any description in clause 2 of any land to which the benefit of the covenants could be annexed, the conveyance does not clearly identify any benefited land. And just pausing there, you know, this area of law can just seem sort of a morass of unnecessary technicalities. You might think that. What are these requirements doing there? Why is there a requirement that the benefited land be clearly identified in the conveyance? And why is there a separate requirement that the benefited land be easily ascertainable? Why is that? Why have the judges come up with these things when there is no such requirements in relation to an easement?
Don't you have to identify what the dominant tenement is when you?
You obviously, if you have just no idea, you know, there's no one, you can't identify anyone who can enforce it. But for a covenant, as we've seen, the benefited land has to be manifested in the conveyance. It has to be described, or it has to be, you have to be able to identify the benefited land from the conveyance. That's not a requirement in an easement. So you can identify the benefited land in an easement entirely from matters extraneous to the conveyance creating it. I've included in the skeleton a case in support of that. But I mean, just what was going on with these technical rules? So in the 19th century, equity, first of all, made it easier for the benefit of covenants to run with land. And they also, in a sort of revolution in land law, for the first time, enabled the burden of a covenant to run with land. So the restrictive covenants, restrictive freehold covenants, became an interest in land. Now, having done this, the courts were obviously, and this was all before planning law. I mean, that's why this happened, before planning law. So having done this, the courts were keen to place restraints both on the circumstances in which the benefit of covenants can run, and also the circumstances in which the burden of covenants can run. Because they were worried, in general terms, that restricted covenants can last indefinitely, and they can impose really, a restricted covenant restricts either building on your own land or using your own land for some purpose as a result of something which may have been agreed 100 years previously. So that's why you have these restrictions in the law. And when we're thinking about the restrictions the courts placed in respect of the running of the burden, the courts were keen to ensure that an owner of land, but also a potential purchaser of land, who might be a developer, can figure out quite easily who might have the benefit of any covenants. And in that respect, there is a distinction between easements and restricted covenants, because, and this goes to the point made by His Lordship, Lord Justice Nugee, that if a land is subject to easements, it's usually pretty easy to figure out what the dominant land is. If you've got a path running for your land, the dominant land will be probably the property or properties accommodated by the path. If there's a drain running through the land, you follow the drain, see whose property it accommodates. Developers often trying to figure out whether land is burdened by prescriptive rights of light. Well, all you have to do to see what any dominant land might be under rights of light, you just go on the land, you look around, see which windows are overlooking it. In contrast, there is often no way from the terms of the covenant itself to know what land the benefit of the covenant might be annexed. And this is a good example. If you've got a nuisance covenant breached by causing a prejudice to the neighbourhood, that doesn't tell you what land the benefit of the covenant is annexed. This is a bit of a digression. Let me try and get back to my argument. So, what do we make of successors in title here? First of all, even if you accept an intention to annex the benefit of the covenant to land, the land is not clearly identified because there's no description in clause 2 of anything which could be the benefited land. And the fact that His Honour Judge Paul Matthews, made such a sort of mess of trying to figure out what the benefited land is demonstrates that the benefited land is not clearly identified. The second point is that if the benefit of the covenants was annexed to any land, the only plausible candidate in the conveyance is the Bathwick estate. And the argument for that, you can see what the argument is. The recitals to the conveyance tell us what the parties chose to say about the context in which the operative parts of the conveyance were agreed, including clause 2. They do so by saying that the wreck was part of the Bathwick estate, Captain Forrester was the tenant for life, the Bathwick estate, and it was in that capacity he was selling the wreck. So when you encounter in the operative parts of the conveyance a reference to success in title, without any accompanying description of any land owned by Captain Forrester, you can see why it might be said that the answer is you look back at the recitals, and there we hear that Captain Forrester was an owner of the Bathwick estate. But if that's right, that doesn't help the respondents. And that's because of what has always been understood to be the effect of annexing, or what has always been thought to be the likely effect or likely construction of a covenant annexing the benefit of the covenant to a named estate. So if we could have a look at the bundles of authorities. First of all, there's a second volume of it. And if you could turn to divider 43, so hopefully you've got the right front sheet, front page. So this was the only book on dedicated to restricted covenants at the date of the 1922 conveyance. Initially, we got the wrong front page, but it should be at the 1909 first edition.
Not for me, page.
Oh, right, I can pass up there.
Tab 43.
Tab 43.
I'm afraid I'm racing into the second edition in 1931.
Right, so I can pass up the correct page.
I'm post the 1925 Act. Thank you very much.
Yeah, the pages are in fact from the first edition.
Right, so I've got the right text, but the wrong.
You got the right. I photocopied this. It was from the first edition. I lost the front page. It was supplied to me. I didn't initially notice that it was the second edition.
Thank you very much.
So this is the only practitioner book at the time dedicated to restricted covenants, written by Arnold Jolly, who's a barrister based in Lincoln's Inn. And at page 42, you'll see at the foot of the page, in some cases, an intention is shown to annex the benefit of the covenant to a particular estate named, but not otherwise defined, as for instance the Calverley estate in Kelsey and Dodd, the Branscombe estate, and the Earlsfield estate. In such cases, the words are construed as meaning the estate in question in its popular and broad sense, and not every lessee or purchaser of a small plot. So that was what the only book dedicated to restricted covenants at the time told us about what a reference to a named estate is. If we can now look at one of the current books on restricted covenants, Divider 46, written by another barrister in Lincoln's Inn, Andrew Francis. And at page 154, Page 154 at the top, he says that in the context of the examples above, which refer to defined estates, one question which can arise is whether the estate is defined at the date when the covenant is imposed, and assuming that it is certain as a matter of evidence, must be at least identifiable when at a later date the covenant is being enforced. It is suggested that at any later date, the estate should be identifiable and still in existence as an entity, if the party seeking to enforce the covenant is to succeed in claiming the benefit of the covenant. And the court will find at Divider 3, Kelsey and Dodd, which was referred to in Mr. Jolly's book, so this is a judgment by the Master of the Rolls, Sir George Jessel, who, as a junior barrister, specialised in conveyancing. And page 35, you'll see left-hand column, maybe about 8 lines down. So, I mean, the facts are two people called Ward were the owners of an estate called the Calverley Estate. By a 1965 conveyance, they sold 6 acres of the estate, and the estate contained a covenant by the purchaser against keeping a beer shop, which I assume is a kind of off-licence. And page 35, 8 lines down, left-hand column, you'll see the covenant was entered into with the 2 wards, their heirs and assigns, and also separately with the owners or owner, lessors and lessees for the time being, or other persons or person for the time being entitled to the receipt of the rents and profits of any part of the Calverley estate. Then right-hand column, first full paragraph about 8 lines down, the judge said, Master Rolls said that this was obviously a covenant for the protection of their estate from nuisance. And then about 10 lines from the bottom of that column, the covenant was with the 2 wards, there and each of their heirs, successors in estate, appointees and assigns, and also separately with the owner and owner, lessors and lessees for the time being, or other, the persons or person for the time being entitled to the receipt of the rent and profits of any part of the said Calverley estate. There is no definition of Calverley estate in the covenant, but the evidence of Mr. Ward is clear enough that there was an estate bought by his father in 1828 or 1826, or somewhere about that date, which he named the Calverley estate, and that from time to time he sold a piece of it, and of course the Calverley estate was the name of the remainder. Now I think, according to the legal view of it, the Calverley estate must mean that estate to which remained unsold and belonged to the wards, and does not include portions of the estate which had been sold off, and which, though at the time they were sold were properly described as forming part of the Calverley estate, could not, I think, be properly so described after they were sold. Therefore, owners and lessors and lessees for the time being means the future owners of the Calverley estate. Now, apart from being providing support for the natural meaning of a reference to the Calverley estate in a covenant, this is quite good evidence about what the parties to the 1922 conveyance meant by Calverley estate.
I think you said Calverley estate, you mean the Barthwick estate? No.
Yes. Yeah. Yeah, the drafter would have had this in mind. Competent drafter would know what, at that date, a reference to an estate is generally intended
Just
to.
help me on one thing, going off briefly at a tangent. So suppose you're right that, well, I know you don't say this. Suppose it were the case that you could infer that the covenants were for the benefit of the Barthwick estate. And suppose the Barthwick estate means such of the estate is as for the time being unsold. Now Captain Forrester wants to sell a further part of the Barthwick estate. Can he assign the benefit of the covenant?
Yes.
The benefit of that part?
The rules on assignment are different. So we're just talking about annexation.
So to be clear, even though the covenant is for the benefit of the estate as a whole, he can still assign for the benefit of part.
So I'm just not sure what the answer is.
I mean, commercially, one might think that he would want to have that ability. He wouldn't want to be confined to giving the benefit of the covenant, supposing it to be intended to be for the benefit of the whole estate, only if he sold the whole estate rather than selling off some property immediately next to the wreck.
Immediately, I'm not sure what the answer is to that.
Yeah.
Maybe I could think about that. no doubt my learned friend will, we can revert to that question.
I have some idea that at law you couldn't assign the benefit of a covenant in bits, but in equity you can. But I may be wrong about that.
I mean, the rules about assignments are much more relaxed and different. But my Lord, Lord Justice Newey, it's a good question, and we will give some thought to that.
Following up from that, I would quite like to understand what you say the commercial purpose of including the word successors and title in the 1922 conveyance was.
Well, as I've said...
Who is intended to be encompassed on your submission by those words?
So in my submission, the answer is unclear. And the benefited land has to be clearly identified. And in the absence of any description of any land, which could be the land to which the benefit of the covenants was annexed in clause 2, the answer is unclear. And we can see it's unclear because of the train of incorrect reasoning that this judge came up with. But what I said a moment ago, that the most plausible candidate is the Bathwick estate.
So what does that mean? We know Captain Forrester was tenant for life under a strict settlement. We know that he had in fact been trying to dispose of the whole estate. But presumably, if he had succeeded in selling the whole estate in one lot, the person who bought it would be a successor in title within the meaning of the covenant?
Yeah, that's right. You'd need... Who is the... Look, the question, if you're asking who is the successor in title of the Bathwick estate, you're looking for someone who can be described as the owner of the Bathwick estate.
What about if he died as tenant for life and the next person entitled under the settlement?
That was a point taken below. We don't take that point. We don't take any point that he was the tenant for life under a settlement. But if the covenant benefited land, the covenant was imposed for the benefit of Captain Forrester and future owners of the Bathwick estate. It can only be enforced by someone who can be said to be an owner of the Bathwick estate.
That means as a unit, kept together as a unit.
That's right. I mean, and it needn't be under that particular settlement. But you need something you can call the Bathwick estate. So you may have seen that in 1924, the estate was incorporated. It was transferred to a company. But nevertheless, the company was the owner of the Bathwick estate.
So they would be a successor.
They would be a successor in title to the owner of the Bathwick estate.
Your point is that it wouldn't be the purchaser of one house.
No, they wouldn't be the owner of the Bathwick estate.
So the Bathwick estate, you say, would be, if you like, the rump of the Bathwick estate from as it was from time to time, as opposed to what it was originally before any.
That's right.
Was sold off.
It's something like that. I mean, you'd have to look at the particular facts, and you'd be just simply asking yourself, is this person the owner of the Bathwick estate? So if
Now, I'm just picking up my lord's point. You wouldn't have to say in order to be a successor in title, they had to have the whole.
No,
of the Bathwick estate.
I mean, it'd be a question
the
of
Bathwick
fact
estate
to a degree.
as currently identified.
If you sold off a quarter, but I mean, and that is the natural way of interpreting this sort of covenant. You know, if you make a covenant with the owner of the Portman estate and any successors in title, you're not covenanting in a way which means that the owner of any house on the Portman estate can enforce the covenant.
Can I just talk around for a moment the point you're not pursuing, so I understand it? I know there was a resettlement under which Captain Forrester was tenant for life. I haven't looked to see what happened after his death, was there then another tenant for life?
Well, in 1924,
But in 1922, when the conveyance was executed,
the son became the tenant.
he became tenant for life.
And that was before 1924.
There was a disentailing insurance and resettlement, was there not?
I wonder if my learned friend, Mr. Hutchins, is better placed to. I mean, I do remember, as I said, it was sold to a company in 19...
That was 1924.
But in 1922, you still had the resettlement in place.
Yeah.
So
That's right, there was a resettlement in 1920, I think.
on the death of Captain Forrester, I forget actually, pre-1925, the legal estate doesn't go to the next tenant for life, does it? It's that the power of sale goes to the next tenant for life.
Yes, but I think tenants for life may have a legal interest
Yes,
in
that's
the land.
Well, no, I think not sure about that. The trustees of a settlement would have to fee simple, would they not?
But they...
No?
I think that's post-1925, but not pre-1925.
I thought post-1925, the tenant for life got the fee simple. Is that right?
It's held by the trustee.
Yes, I see. Okay.
And so you have successive legal interests under the law as it stood in 1922.
You had a legal life interest in Captain Forrester with
Yeah.
a power of sale of the freehold. That's what the power of sale was.
And that is given by the 1882 Act.
Yes,
Which is
but the freehold that he has power to sell is not vested in him. It's vested in the settlement trustees, is it not? The capital money is paid to the settlement trustees.
the capital monies are paid to the settlement trustees, but I don't think the legal estate is vested in him. And what the 25 Act does is to effectively vest the legal estate in the trustees.
And the tenant for life becomes an equitable tenant for life, yes.
Exactly.
But going back to my Lord's question, in 1922, if Captain Forrester had been struck down by an omnibus the next day, who would step into his shoes as having power to dispose of the estate?
His son, who was under the
disentailing insurance and
Yeah.
resettlement, was the next entitled.
party.
Thank you. Well, can I now ask the question, would that person in those circumstances be a successor in title to Captain Forrester? If his son became the next tenant in possession, would he be a successor in title?
Well, we're not taking that point.
But he would be the owner for the time being
Yeah.
of the Bartwick estate. So
Yeah.
why is he not a successor in title?
As I say, we're not taking any point arising from the fact that there was a settlement of this land.
I've not quite understood what you mean by that. Because I thought you were saying that successor in title meant anybody who became the owner of the Bartwick estate for the time being.
Yes.
That's what puzzles me.
Yeah.
Would Captain Forrester's son, if he succeeded to the estate,
I'd say
not-
yes. Yes.
He would.
Yeah.
My Lord, we don't accept that. I mean, and this is something we've divided up tasks here. The point is that you have separate legal estates existing at the time in 1922.
So he doesn't succeed to a life tenancy.
He has a different.
He's got his own.
because he's.
Is he tenant in tail, or is he another tenant for life? Or?
I think under the resettlement, he's another tenant in tail.
Right.
So he has a separate legal title.
He's got an estate tail, which is a separate legal estate from the life estate, which his father has.
Exactly, and
that's why he's not his father's heir, and you say he's not his father's successor.
Exactly.
Just before we leave this subject, at the risk of causing further confusion, I see the easement provision refers both to successors entitled and heirs,
Yes.
whereas this bit only refers to successors entitled.
Yes, and that we say is important because what it's effectively doing is saying that the easement is for the benefit of the current owner, as it were, Captain Forrester, and the heirs to the settlement. So, in other words, it's for the benefit of everyone who succeeds under the settlement. And it's an important point of distinction between Clause 1 and Clause 2.
No doubt you will tell us in due course, but I'd like to hear from you in due course who you say successor in title does mean, if it doesn't mean Captain Forrester's son.
Yes.
Purchasers of the estate as a whole.
It would include that. But maybe I could address you at, rather than take Mr. Weeks out of his trial.
So, I mean, whether there's a point arising from the settlement, and I'm not arguing one, a successor in title of the owner of the Bathwick estate has to be someone who can be described as the owner of the Bathwick estate. And there are lots of cases in support of that. The most important one I've taken you to, but also Divider 15, in re Ratton estate. So the tenant for life under a settlement of the Ratton estate conveyed 82 acres of the estate to a local authority to be used for a park, and the conveyance contained restricted covenants by the local authority with the owner or owners for the time being of the Ratton estate. And we see that at page 561. So about 7 lines down, the corporation covenant for themselves and their assigns, with the said Freeman Thomas and other, the owner or owners for the time being of the Ratton estate in the said county of Sussex, is in their heirs and assigns. Page 562, you'll see Mr. Justice Harman says the covenant does not purport to be made with the owner for the time being of any part of the Ratton estate, but with the owner of the estate as a whole, and there appears to be no such owner. The deeds are still in the hands of the vendor solicitors and have been handed over to any purchaser. That is evidence that the Ratton estate as such has not passed to anyone as a purchaser, and it seems to me impossible to say that there is anybody now in a position to enforce these covenants. Also, Divider 30, a bit more up to date, Dano and Cadogan. This was a 1929 conveyance of part of the Cadogan estate to the local authority. It imposed a covenant not to use the conveyed land save for housing the working classes. And at page so we've got both the first instance and Court of Appeal reports here. So if you go towards the back of the reports to page 1014 of the Court of Appeal report, there was a covenant. This is about 6 lines down. It was a covenant with the vendor and his successors in title as owners of the property adjoining or neighbouring to the property hereby assured, so long as such adjoining or neighbouring property, when any parts thereof forms part of the Cadogan settled estate in Chelsea, but not further or otherwise. And you'd have thought that just makes it absolutely clear that not only does the owner have to be the owner of the Cadogan estate, but also subject to that settlement. But it was nevertheless argued the contrary. But at page 1017, Lord Justice Carnworth made a more general comment about annexing land by reference to a named estate. He says it's not, paragraph 14, it's not unusual to find the benefit of a restricted covenant annexed to land described by reference to a named estate. In such a case, it will be a matter of construction of the particular covenant whether it continues to apply to land originally within it, wants the named estate to cease to exist in any recognisable form. Had the covenant here referred simply to the Cadogan estate in Chelsea, there might have been some room for argument. However, the inclusion of the word settled leaves no doubt at all. It necessarily directs attention to the settlement as it then existed, and not to a different legal arrangement created some 30 years later. So, I mean, the point I draw from all this is that the conventional and natural interpretation of a covenant which annexes the benefit of the covenant to a named estate is to the owner of the estate and its successor in title, is that the reference to successor in title is to a successor in title who is the owner of the named estate. And that's the interpretation. If it's the case, contrary to my primary submission, that the benefit of the covenant was annexed to the Barthwick estate, that is the interpretation that the court should place on the reference to the Barthwick estate. And as we've said in the skeleton, this doesn't seem to be an issue. The Barthwick estate no longer exists. Having been incorporated in 1924, it went into, the company went into members' voluntary liquidation in 1974, and its assets were sold off and the Barthwick estate ceased to exist. And the references are core bundle, page 115, paragraph 19 of the judgment, and supplemental bundle, page 376 to 379. There's a couple of letters that make that clear.
I thought when it went into members' voluntary liquidation, some of the assets were distributed in specie to other family trusts.
Well, they were.
But there was still no sort of unit you could hold.
Exactly. The Barthwick estate no longer. There's nothing you can describe as the owner of the Barthwick estate. The Barthwick estate no longer exists
As an entity.
as an entity. There's nothing that you could call the Barthwick estate. It's been broken up and sold off.
Well, not necessarily sold off. Some bits of it might still be held in family settlements.
They might be held in family settlements, but as a matter of the ordinary English, the Barthwick estate doesn't exist.
Well, the assets of the Barthwick estate were distributed
Yes.
variously, which may have included distribution into other settlements.
That's right.
connected with
The letters
Barthwick
tell
estate.
you what happened. Final submission. If, contrary to everything I've said up to now, the 1922 conveyance is properly interpreted as disclosing the intention to annex the benefit of the covenants to some clearly identified land, and that land still exists, nevertheless, the covenants are not enforceable because the land is not easily ascertainable. And there are two Court of Appeal authorities which establish that it is a requirement that the land to which the benefit of the covenant is annexed must be easily ascertainable. The first one is Marquis of Zetland and Driver, and the second one is at Divider 31 of Volume 1 of the Bundle of Authorities, Crest Nicholson and McAllister. So if I could take you to that case. And for these purposes, we needn't trouble ourselves with the facts of the case. But
Which tab, sorry?
it says tab 31, final tab of volume 1 of the Bundle of Authorities. So if we could look at the judgment of Lord Justice Chadwick, with which the other judges agreed, we can ignore the facts, just look at what he said about the law. Starting at page 2417, the learned judge said, this is about 15 lines up, just below F, in covenants made before 1926, it was necessary to show by construing the instrument in the light of surrounding circumstances that annexation to the covenantee's retained land or some part of it was intended. Express words of annexation were not required if, on the construction of the instrument creating the restricted covenant, both the land which was intended to be benefited and an intention to benefit that land, as distinct from benefiting the covenantee personally, can be clearly established. So this is quoting from McGarry and Wade. And then over the page, he quotes from Section 78 of the Law of Property Act. Subsection 1, a covenant relating to any land of the covenantee shall be deemed to be made with the covenantee and his successors in title, and the persons deriving title under him or them, and shall have effect as if such successors and other persons were expressed. He then considers the Court of Appeal, the Court of Appeal's decision in Federated Homes and Mill Lodge Properties, which considered Section 78. Over the page, at the foot of the page, he starts quoting from Lord Justice Brightman's judgment, and you'll see counsel submitted that there were three possible views about Section 78. One view, which was what he described as the orthodox view hitherto held, is that it is merely a statutory shorthand for reducing the length of the legal documents. A second view, which was the one that counsel was inclined to place at the forefront of his argument, is that what the section only applies, or at any rate only achieves annexation, where the land intended to be benefited is signified in the document by express words or necessary implication as the intended beneficiary of the covenant. So that's the pre-1926 position. A third view is that the section applies if the covenant in fact touches and concerns the land of the covenantee, whether that can be gleaned from the document itself or from the evidence outside the document. For myself, I reject the orthodox view, and he said he doesn't find it necessary to choose between the second and third views. And then over the page, paragraph 30, in Crest-Nicholson, Lord Justice Chadwick said the decision of Federated Homes case leaves open the question of whether Section 78 of the 1925 Act only affects annexation when the land intended to be benefited is described in the instrument itself by express words or necessary implication, albeit it may be necessary to have regard to evidence outside the document fully to identify it, or whether it's enough that it can be shown from evidence wholly outside the document that the covenant does in fact touch and concern land of the covenantee. Paragraph 31, the learned judge in our case put a lot of emphasis on this. He said it is clear, it reads, it is clear from Lord Justice Brightman's reference in the Federated Homes case to Rogers and Hosegood that it is sufficient for the conveyance to describe the land intended to be benefited in terms which enable it to be identified from other evidence. In our case, the learned judge thought that that was all that was required. But in my submission, that wasn't what Lord Justice Chadwick intended, and he wasn't trying to suggest that it still wasn't a requirement, that the covenants clearly identify the benefited land and the land be easily ascertainable. It's just impossible to read that from that sentence. Paragraph 32, he said that the question left over in Federated Homes was answered in the Marquess of Zetland case. And then over the page, we see the passage I've taken you to previously, including between B and C, the reference to the land needing to be easily ascertainable. And paragraph 33, in its later decision in Federated Homes, this court held that the provisions of Section 78 had made it unnecessary to state in the conveyance that the covenant was to be enforceable by persons deriving title under the covenantee or under his successors in title, and the owner or occupier of the land intended to be benefited, or that the covenant was intended to run with the land intended to be benefited. But there is nothing in that case which suggests that it is no longer necessary that the land which is intended to be benefited should not be so defined that it is easily ascertainable. in my view, that requirement identified in Marquis and Zetland and Driver remains a necessary condition for the annexation. So Lord Justice Chadwick is a bit compressed, but he's saying that there are two separate requirements. The benefited land must be defined in the conveyance, it must be manifested in the conveyance, and also as a separate requirement that it's easily ascertainable.
Do they need to be separate requirements? Or might not the easily ascertainable be an aspect of the first requirement that you've identified?
Or easily, well,
I think that the judge says, well, they mean the same thing. Well, that may be right, but that may mean it has to be easily ascertainable from the conveyance and the surrounding circumstances.
you can bundle it up as a single requirement, but unpicking it, you need the benefited land manifested in the conveyance. It has to be done in a way that's easily identifiable, and also, as a matter of evidence, it has to be easily ascertainable. All of that is in there. And we know that there is a separate easily ascertainable requirement, because in paragraph 36, when the judge quotes from Marquis of Zetland and Driver, I mean, just look at the passage in italics. It quotes the Court of Appeal as saying, it is expressly stated in the conveyance to be for the benefit of the... This is why there are reasons for saying that annexation had happened. It is expressly stated in the conveyance to be for the benefit of the unsold part of the land comprised in the settlement, and such land is easily ascertainable. So it's just obvious that there's two, well, you can bundle them up together, but there is a separate, easily ascertainable requirement.
Well, the importance of it by the judge is, we can see also back in paragraph 32 that you took us to, where the judge again used italics and his own emphasis.
Yeah.
Thirdly, the land which is intended to be must be so defined, and that's this judge's emphasis.
Yeah. And it's always been, I mean, it's always been assumed that for the past 80 years or so, there has been this requirement by judges and legal commentators and textbook writers. So now I get to answer my Lord Justice Nugee's question, I think he posed earlier, which is that I mean, let's assume that the benefited land, let's assume the conveyance would otherwise have annexed the benefit of the covenants to the Bathwick estate. Let's assume that. Was the Bathwick estate easily ascertainable? There's a question about whether it's got to be easily ascertainable at any time, but it would certainly have to be easily ascertainable in 1922, when the covenant was imposed. And in 1922, the Bathwick estate was not easily ascertainable. So if we could look at the supplemental bundle, first of all, page 235. So this is what my instructing solicitors have called the non-conveyance plan. Because there was no conveyance plan, but there was a plan provided to the purchaser at the time. And here it is, and it doesn't show the Bathwick estate or any retained land of the vendor.
Sorry, what page is that?
This is page 235.
Thank you.
There is no description in the conveyance of the land in the Bathwick estate. So what would you have had to do in 1922 to work out what was in the Barthwick estate? From publicly available information, it would have to be publicly available information, I would suggest. Well, first of all, you'd have to get, it would be something like this. First of all, you'd have to get your hands on the auction particulars of the 1919 auction, which we've looked at, and that tells you, that does describe every property in the Barthwick estate. We looked at that before, that's at page 70, we needn't go to it now. Then you need to get your hands on the auction particulars when in 1921 there was an attempt to sell part of the Barthwick estate in individual lots. That's at page 185. Probably no need to look at that. Then you need to work out what was sold at that auction. So you then start researching newspaper articles, and we've got some newspaper articles recording what was sold at page 228 to 230. And they're pretty much illegible, I'm afraid. But these newspaper articles tell you what was sold at the auction in the auction room. And then you've got to somehow try and work out what was sold at the auction but outside the auction room, and also what might have been sold otherwise between 1919 and 1922. And so far as we've been able to work out, and we've done really extensive research, there was no obvious way of doing that.
You said it had to be publicly available documents. The obvious source of information as to what part of the Barthwick estate remained unsold would be the solicitors to the settlement.
Well,
could you not just ask them to tell you?
I would submit, I mean, this hasn't been explored in the case law, but when you're asking whether the benefited land is easily ascertainable, that must refer to land that must mean it's easily ascertainable from material which you have a right to see. Must do. It can't be referring to material which someone else has, in which they could refuse to provide to you. And in that regard, the conveyance itself provides no obligation on the vendor to provide that information. But for these reasons,
you don't. This is a pre-1925 conveyance. Do you not have a right to inspect the covenant to produce title deeds?
Well, it might be title to the land conveyed.
Yes, but the title to the land conveyed is likely to consist of the title of the whole estate, which would normally have endorsed on it those bits which have been sold off.
Well, it might do. So for these reasons, my submission is that whether there's any requirement that the land be easily ascertainable subsequently, for the reasons I've said, the Barthwick estate in 1922, what was in it was not easily ascertainable. My lady, my lords, unless there's anything else I can help you with now, they're my submissions.
Thank you very much indeed. Yes.
My lady, my lords, we adopt Mr. Weekes's submissions as second appellant. And just to be clear why we are involved in this appeal, not having taken a role below, as I think you're aware, we are a charitable trust, and we run a number of events from the recreation ground. Music events and festivals, including the Bath Marathon, a charitable event, and the Bath Music Festival. And these are very popular events. But inevitably, with any popular event, particularly ones perhaps involving music, there are, we would say, a minority of local residents who object to such events. And obviously our practical concern, and the reason for joining the appeal, is because of the very wide nature of the nuisance covenant, which Mr. Weeks has outlined, which I accept, and which could potentially at least restrict our activities on the recreation ground. I adopt Mr. Weeks' submissions. I want, however, to say really to cover two things, and that is to address the true construction of the conveyance, where I will particularly address the successors and title point, and also just to add perhaps one or 2 points about the easy ascertainability test. And what I want to cover in relation to the conveyance is 4 things. First of all, the Bathwick estate as a possible candidate for being the benefited land. Secondly, I want to cover the meaning of the restriction itself, the terms of the restriction rather than the operative words of the covenant. Thirdly, I want to address successors in title and assigns as used. And fourthly, I want to address the lack of words of severance. And by that I mean that even if you're against us and the benefited land is somehow properly identified, there's no reason for thinking that the benefit attached to each and every part of the retained land. That's our ground 6, and it's Mr. Weeks's ground 3 of the grounds of appeal. Starting then with the first point about the conveyance and the possible candidate being the Bathwick estate, we say very simply that it is not a candidate, it's not even a possible candidate. Where the words Bathwick estate are used in the recitals to the conveyance, and they are used effectively in 4 places, if I can take you to 236, you'll see that about halfway down the page is the first mention of the Bathwick estate. And that is clearly to identify in the recitals the settlement of that estate on the 19th of July 1920, which is the deed of resettlement, which we'll look at. There is then a reference to, in 2 lines below that, to hereditaments hereinafter described form part of the said estate, but which don't include the hereditaments hereinafter described, to uses under which the vendor is tenant for life in possession thereof, again, possession of the estate, and by the settlement, trustees were appointed to be trustees thereof. Again, that's the 4th reference to the Bathwick estate. Now, each of those references is clearly serving the purpose of showing to the purchaser the devolution of title and explaining why the vendor is entitled to sell the particular portion of land and why the trustees are being made a party to the conveyance. It's clearly not, doesn't demonstrate an intention to identify benefited land. We say that simply the Bathwick estate is not a candidate on any feasible construction of the words where Bathwick estate where they're used in the conveyance. And the second point then we make is in relation to the words of the restriction. If I can take you then over the page to page 237, and I'm now looking about 10 or 12 lines up. Again, Mr. Weeks, I think, has taken you to this, that no workshops, warehouses, factories, or other buildings. Now, on any basis, we say that the words of the restriction are ambiguous. On the face of it, if you were seeking to impose simply a nuisance and annoyance covenant, you might have thought that the drafters would have started with the words, no nuisance or annoyance shall be caused, and in particular, no workshops, warehouses, factories, etc. may be built. And we say that one possible reading of this, and we don't ask this court to determine the meaning, we could have done below, or my learned friend could have done below as part of the application, but didn't do so. But we say that a possible interpretation here is that this provides an absolute restriction on workshops, warehouses and factories, 3 types of properties, and then a 4th type of property is also absolutely restricted, and that is trade or business buildings which cause a nuisance or annoyance. So in other words, one puts brackets around after the word factories, and then the next bracket doesn't come until after 2 lines down, after neighbourhood. So in other words, 4 types of building shall not at any time hereafter be erected on the hereditaments and premises, except the part in the occupation of Aircraft Limited. And we say that can't mean that you can build a building which causes a nuisance or annoyance on Aircraft or Artcraft Limited's land. It's saying that in relation to Artcraft's land, you can build at least workshops, warehouses and factories, and then we go on and see that no factory chimneys can be built. So in other words, the second part of the covenant, which Mr. Weeks rightly identified, is that part that begins after Aircraft or Artcraft Limited, and that nothing shall hereafter be erected, placed, built or done on the hereditaments, and that's the whole of the land. So what we glean from that, and of course there is some repetition there, because if nuisance and annoyance, buildings that are for trade or business cause a nuisance or annoyance, having been built, then they're also caught by the first part of the restriction. But the second part really stands as a separate restriction, a general restriction against nuisance and annoyance, etc. And then, as Mr. Weeks rightly says, the final restriction is, again, an absolute restriction on factory chimneys on the Artcraft land. And just for your benefit, you've been taken to 235. The Artcraft land is the land coloured green, and the pink land is the other land. And we know that because 2 days after this conveyance, the Artcraft land was sold off to Artcraft Limited. Now, the importance of that, if that's a possible construction of the words of restriction, is that it makes it all the more unlikely that the drafters of the conveyance would have wanted to identify the benefited land by reference to the second part of the covenant, which is really the general nuisance and annoyance covenant. If it operates, as it certainly does, in relation to chimneys on the Artcraft land as an absolute restriction, and we would say might well operate as an absolute restrictions on workhouses, warehouses and warehouses and factories on the pink land rather than the green land where they can be built, then we say that makes it highly unlikely that the drafters would have thought that the benefit of the covenant was to be attached to the land that is in effect in a subsidiary part of the restrictions. If one can illustrate this best by perhaps looking at the Artcraft restriction, which is plainly an absolute restriction on chimneys. If I build a very small chimney on the land, it's a breach of covenant. An injunction might not be granted, and that damages might be nominal. But it's a breach of covenant Why then is the benefited land in respect of that breach necessarily and clearly the land, the premises adjoining or the neighbourhood? It simply suggests, in my submission, that the drafters cannot have been thinking of those words as being a proper identification of the benefited land. Then the third point we make about the conveyance is to look at the words successors, entitle, and assigns. In that regard,
Before you come on to that, you at one point you said, or possibly aircraft. Do you know which it is? Is it just a question of trying to read the indenture?
well, can I take you to the... We think it's aircraft because, I think this is probably the only point I disagree with Mr. Weeks on, but we think it's aircraft because where we have the conveyance, 233, which is a very unclear, but if you look at the word provided about 3/4 of the way down, and then you go directly above provided, 4 lines up, there is the word aircraft, and we say it's aircraft because there seems to be a dot over the I, Aircraft Limited.
Yes.
Certainly doesn't seem to be a T, does there?
No, or an R. I mean, a small point. But
It doesn't matter.
It doesn't matter, but we think it's aircraft. In this regard, we make really 2 points. And the first point is to look at the words, look at how the judge dealt with this. And what he said at paragraphs 47 to 60 of his judgment at Core Bundle 123 to 126, relying significantly on the word successors entitled, he said that indicated an intention to annex the benefit of the covenant to land of the covenantee. We agree absolutely with Mr. Weeks that then sends him off on a rather contrived trail to then try to find what the benefited land was. And he says at paragraph 50 that successors entitled is far more potent in showing an intention to benefit particular land than the phrase heirs and assigns. And we make 3 points about that. First, we say by reference to the authorities that these words, whether it's successors or heirs and assigns, are not generally read as words indicating an intention to benefit particular land. The second point we make is looking at the precise wording in the conveyance set in its context. We say that, in particular its settled land context, we say that is not the correct reading of the word successors entitled. And then thirdly, we just look at if we have time, we will look at the judge's reasons for rejecting Balthrup's contentions in that regard. So firstly, dealing with the authorities, the judge below, Judge Matthews, was taken to the Sainsbury's case, and perhaps I can just refer to that. That's bundle 1, tab 26. It's the judgment of Mr. Justice Morritt as he was, and it's at 448, about halfway down the page. The marked part, can I just ask you to read the part that begins, if it had been intended? So we know from that Section 58 of the 1881 Conveyancing Act doesn't assist in terms of the use of the words heirs and assigns, doesn't deal with the word successors. And then the second authority, which I don't think the judge was below was taken to, is the University of East London Authority, which is at tab 33 of the bundle 2. And it's pages 365 to 366. And I think this part is not actually marked in the bundles, but Mr. Justice Lightman there deals in general terms with the words vendors and purchasers at 29, and then successors and assigns. And if I can ask you just to read paragraphs 30 and 31. Particularly between C and D in paragraph 32.
Sorry, in paragraph?
Sorry, paragraph 32, between C and D in particular. Particularly between C and D. And then finally, just one further authority, which is Lamb and Midak, which is back in the first bundle of authorities at tab 18. And this is the judgment of a powerful Privy Council, including Lord Nichols, Lord Millett and Lord Hoffman. Lord Millett sets out the relevant covenant. We don't need to really trouble with the facts, but he sets out the relevant words of the covenant in paragraph 3. We see the word there used included, or the words there used included transferees. And the point is dealt with at paragraph 8 and particularly paragraph 9. So in relation to the word transferees, their lordships concluded that standing in conjunction with the reference to personal successors, but otherwise alone and without elaboration, the word couldn't evince an intention to annex the benefit of the covenant to land. Too much uncertainty to know for whose benefit the covenant was taken. On this short ground, the alternative basis of Mr. Lamb's claim must fail. And of course, transferees in that context can only have meant transferee, or one would have thought, meant transferees of the estate in land. And yet, in that case, the courts say, well, even that is insufficiently clear to attach the benefit to particular land. We have different wording here. We have the words in title after the word successors, but we say that that simply doesn't add anything. The authorities show that successors is itself ambiguous and not intended to denote particular land. Well, the use of the words on the face of it, successors in title, makes no difference. And we say that the better reading of this, which I shall explain shortly, is that it was effectively a personal covenant, the benefit of which could be transferred and would be transferred to successors in title to the life interests that Captain Forrester held, the legal estate that he held as tenant for life. Because, of course, by this stage, as we'll explain, the tenant for life was able to convey away his own interest, to mortgage it or to sell it, but also, as a result of the 1882 Act, he could also effectively bind all other estates that existed in relation to the settlement, all other legal estates, the legal estate of his son as successor, and the legal estate in remainder. And for that reason, at very least, the covenant is ambiguous. But I'll come on to develop that point. Just want to take you, while we're in the authorities, to one final case which supports the idea that the covenants were personal rather than intended to be attached by those words to particular land. And that's Chambers and Randall at tab 7. The importance of this case is really that when the judge is looking at the submission that this was really a personal covenant vested in Captain Forrester, for which he could assign, or indeed which he could convey with the land that he might sell off in future, the judge considers the possibilities of that construction by reference only to the ability to, as it were, secure money for the release of the covenant in relation to the sold land. He describes it, the submission being made, as a sort of overage covenant. But of course, that's not one of the reasons why Captain Forrester may well have, not the only reason why Captain Forrester may well have wanted to keep the covenant as his effectively personal property.
Just before you go on, when you say personal, you don't mean non-assignable?
No, I don't mean non-assignable.
Which is one meaning of personal. You mean non-annexed?
Non-annexed,
Yes.
Absolutely. And we know that it was intended to be assigned because, of course, the phrase is not successors in title alone, it's successors in title and assigns, which makes clear it was intended to be assignable. But can I just take you then to Chambers and Randall at tab 7. Which is a case which is illustrative of a couple of points, really. So this is a case from 1922, in fact, where the words of covenant appear on the first page, page 149, the said Humphrey Wood, for himself, his heirs, executors, and assigns hereby covenants with John Bulbrook, his heirs, executors, and administrators, that no dwelling house is to be erected on the piece of land hereby conveyed, etc., etc. And then a general nuisance and annoyance provision, the important points being the last lines on that page. So no trade or business of a noisome or offensive nature can be done on the premises, which may be or become a nuisance to the tenants or prejudicial to the value of the houses belonging to the said John Bulbrook in Cambridge Terrace, adjacent to the said premises, page. And a priori, you might have thought, reading those words, that the benefited land was plainly John Bulbrook's premises in Cambridge Terrace, which are clearly identified in the words of restriction. Now, if I can take you to 155, and it's marked parts, there the judge deals with the argument that the covenant was annexed. He refers about 3/4 of the way down the page to Rogers and Hosewood, and says this is a question depending on the construction of the covenant. In my judgment, this case is not one in which the benefit of the covenant was intended to or was annexed to the 9 houses in question. It seems to me to be the case on the clear language that Mr. Bulbrook was not intending to enact the benefit of these definite houses so that it would pass to any purchaser from him or any one of the houses, but was obtaining a covenant which would be of use to him for the protection of his houses in his own hands and for enabling him to dispose of the houses advantageously to anyone with whom he may deal in future. And he then goes on to support that over the page by reference to Masters and Hansard. And he says about 7 or 8 lines down, so here it seems to me that in this case the object of the covenant was to enable Mr. Bulbrook to protect his property while he retained it and make the most of it when he disposed of it. It might have been competent for Mr. Bulbrook to realise the benefit of the covenant by stipulating with the purchaser for any houses from him that he, the purchaser, should have the benefit of the covenant assigned to him, and he might in that way have obtained a better price from the purchaser. The possibility of that is considered in Reynolds and Cowlishaw. So we say that the words successors and title are ambiguous, and that one good reason why the covenant was expressed to be assignable, as it were, to successors in title, is because Captain Forrester would have wanted to exploit the benefit of the covenant when he sold off other bits of the estate, as he was trying to do. So, can we look at the words successors in title, please, on page 236? And what we say is striking is that where the words successors in title and assigns, or successors and assigns, are used elsewhere, the drafters have carefully identified the land with which that particular phrase is linked. So if we look at clause 1, we see that on page 237, the reservation to the vendor and his successors in title and their heirs and assigns for the uninterrupted running of water and soil from the other buildings and land of the vendor. So there, successors in title is clearly linked to land of the vendor, no doubt about that. When we look again at clause 2, we see, when we look at the habendum, the words beginning to hold unto the use of the purchasers, their successors and assigns in fee simple, we see very clearly that that's intended to relate to particular land, the fee simple that is being sold. Again, when we look at clause 2, we see that the purchasers, for themselves, their successors and assigns, hereby covenant, with the intention that the covenant shall run with and be binding on the hereditaments and premises. So there, where the word successors is used in the first line, it clearly relates to the land that is being sold, the separate portions of the hereditaments that are later identified as being binding by the particular parts of the covenant. And yet, where in the key use of the phrase successors in title in the following line, hereby covenant with the vendor his successors in title and assigns, there is no identification of benefited land, which is particularly surprising because the drafters have been careful elsewhere, and particularly where they're trying to identify the successors in relation to the burdened land, they're particularly clear to identify which land is in fact burdened. So we say, first of all, that looking at those words, that phrase in the second line of clause 2, the vendor, his successors entitled and assigns, is not clearly linked in the way that other uses of the phrase are to particular land. But the second point we make is that the judge, this is our ground 1, the judge was wrong to reject the contention made by counsel appearing below for the first appellant that successors in title referred to successors in relation to the settlement. We know, and we need to look at the recitals of the conveyance to see that the parties are clear in showing the devolution of title. What the judge said about the submission was that the phrase successors in title, in its ordinary, this is paragraph 54 of his judgment, in its ordinary property law sense, refers to those who become owners successively of an estate or interest in a particular parcel of land. In that ordinary sense, it does not refer to successive tenants for life in a strict settlement. Now, if that was the submission that was made, that may be right, but it rather misses the point. We are dealing here with a strict settlement. We're not necessarily dealing with the ordinary meaning of successors in title. And we know from the background that the deed of resettlement, which appears at page 124 of the supplemental bundle, by that deed, prior to that, the Duke of Cleveland had devised his fee simple estate in the Bathwick estate upon Captain Forrester, who was granted a life interest. And under that will, we see at 125, a tenancy in tail was granted to his first, Captain Forrester's first and other sons. Now, the deed of resettlement effectively resettles the Bathwick estate for an estate in fee simple. And clearly what had happened here is that at the age of 21, Captain Forrester's son, Henry, agreed with his father to enter into a deed of resettlement for an estate in fee simple in order to prevent the son from doing what was apparently quite easy in those days, which was to bar the entail and therefore be able to sell the land off or sell his interest off as he saw fit. So under the under the deed of resettlement, Captain Forrester is granted the first life interest, and we see that at page 138 in the supplemental bundle. It's clause 8. We see that that he's granted the interest. Francis William Forrester is granted the interest during his life by way of restoration of the life estate under the will of the Duke of Cleveland, and then at clause 9, to the use of the said Henry William Forrester, during his life with remainder. So in effect, Henry is granted a life interest with remainder, and we can see that Henry's unborn male issue are successively have successive interests. And of course, this is all happening before the 1925 Law of Property Act, but after the Settled Land Act, 1882. And the position at that point was that Captain Forrester held a legal estate. His son Henry also held a legal estate. They were both vested because because the son had reached majority. Both individuals existed at the date of settlement. And those legal estates were, of course, not abolished until 1925.
They're legal life estates.
They're legal life estates.
And then there's an estate tail, which is not vested in possession because Henry Forrester's son's not yet born.
Yeah, exactly.
And then there's an ultimate remainder to the trustees in fee simple under clause 12.
Yes, exactly.
But that's a reversionary interest.
Yeah,
and in practice, it's a long way down, and since you can buy the entail, the likelihood is it won't ever fall into possession.
Exactly. But the point for our purposes, getting back to the nub of the point of the Successors and title, is that at this point, under the 1882 Act, of course, Captain Forrester could grant what he did in 1922 in the conveyance, which is a fee simple, free from the interests of the...
That's because he was given a statutory power of sale.
Yes, exactly.
And he overreaches all the other interests in the settlement.
Exactly. And of course, in 1925, I think those powers are taken away from the life tenant in the sense that they're put that it's the trust.
I don't think so. I think the tenant for life under a strict settlement under 1925 legislation continues to have a power to sell, but the capital money gets paid to the trustees.
Apologies, but those legal estates rather cease to exist, and the only legal estate is the one held by the trustees, who can then to whom capital monies are paid.
The tenant for life gets an equitable life interest, but still has a power to sell the freehold legal estate.
Yes, exactly.
But that, as you say, that's all post 25.
Yeah.
At this stage, Captain Forrester has a legal life interest.
Yes, which he can sell and mortgage.
Although he could, but if you wanted to raise money, he could sell the whole fee simple.
He can. He can, yes. But for our purposes, the important point is that when he's selling the settled estate under the power of sale, he's conveying his own life tenancy and effectively all other legal estates, including his son's. Meaning that the purchaser, in effect, gets a fee simple absolute. And those interests, those legal interests, merge in the conveyance of the fee simple absolute to, in this case, Bath Recreation Ltd. But the important point from our perspective, therefore, is that one has to ask the question, why here are the words successors in title used without any clear and assigns, without any clear reference to any land. On the face of it, first of all, it's ambiguous, but one clear possibility is that which was advanced in the Chambers and Randall case, which is that Captain Forrester would wanted to reserve the right to be able to sell land with the benefit of that covenant. Sell other parts of his retained estate.
Why would that require the words successors in title?
Well, what the words show is that successors in title will, to his own estate, his life interest, will be entitled to the benefit of the covenant, unless he chooses to exclude that from the sale.
I find that a bit confusing. I would have thought, there he is. Well, two possibilities. Either he wants to sell the land, so to speak, or he wants to sell his interest. Suppose he wants to sell the land, and he wants to assign the benefit of the covenant with the land. Fine, but that's catered for by assigns. Yes?
Yes.
Now he wants to sell his interest, which is a very peculiar idea, that he wants to sell his life interest, but not the land. But he does, and he assigns the benefit of the covenant with the life interest. Well, why isn't that catered for by assigns?
Well, it is, but the point is that what this is doing is is effectively creating the presumption that when the land is sold under the life interest, the successor will take the benefit of the covenant without an assignment. But separately, he can assign, and that's the use of the words "and assigns."
It's a very strange idea that it was intended that he should have the ability to assign, but still, in very peculiar circumstances, a presumption should apply.
Well,
I mean, I'm right in thinking, aren't I, Mr. Hutchings? My Lord's referred to being peculiar. If you sold your life interest as a life interest, the purchaser would get an estate per O to V, and his interest would come to an end when you died, something entirely beyond his control. So it's not a very marketable proposition, buying someone else's life interest. Sometimes if people were desperate, they might find a market for it, but most purchasers are not going to take a gamble on how long their vendor is going to live, are they?
well, that may be right, but equally, I mean, it wasn't unknown, I think, for these estates, these interests to be mortgaged.
But again, a mortgagee
It's taking a risk.
is not going to lay out capital money, or not much, on the gamble that the vendor is going to live for X years. The whole point of a settled land act was that you can mortgage the fee simple, which does give the mortgage.
Yeah.
And obviously you don't get the capital yourself, it goes to the trustees, but you get a life interest in the money. If what you want is money, you raise money by mortgaging the estate as a whole, not your life interest. One would have thought. These things are now of historical interest.
Oh, of course.
But we're trying to understand what Captain Forrester's solicitors meant by putting in the word successors in title. And we have to look at what might have been going through their minds at the time. And it does, picking up what my lord said, seem very odd that what they're trying to cater for is the possibility that Captain Forrester might want to mortgage or sell his life estate rather than the powers given to him under the Conveyancing Act, which enables him to mortgage the whole estate.
And moreover, would want to do that without choosing whether or not to assign.
Well, on the first point, I mean, he needs the consent of the trustees, and it may be that
To do what?
to convey the whole estate.
No, he doesn't. The whole point of giving him the power of sale is that the person in possession, the tenant for life in possession, can raise money on it without anybody else's consent. It's just he doesn't get his hands on the money because the capital money is paid to the trustees and is held in settlement, and his life interest entitles him to the income from the investments. But the whole point of the Conveyancing Act, giving the tenant for life of strict settlements the right to deal with the estate, was for there to be one person, adult and of full age and capacity, who can deal with the estate without reference to anybody else. And that's what was done, and that's what Captain Forrester was trying to do when he put the estate up for auction in 1919.
Well,
that's my understanding. As I say, these things are now over 100 years old.
well,
But that's my understanding of how it then worked.
Yeah. Does the same? I'm showing my ignorance of what happened before 1925. But do the same restrictions apply if you're trying to sell your life tenancy, your interest in your life tenancy? Is that the equivalent of pawning?
Well, I don't think those restrictions would apply.
And that's the only reason I could think of it was leaving them with that. Okay, you wouldn't get us anything like the value, if you like,
no,
because it would, as I say, be the equivalent of pawning your diamonds.
Yes.
But it might allow them to do something that otherwise they wouldn't be allowed to do.
Yes, and if the son objects to a conveyance of the whole of the estate, you may want to, of the fee simple, you may want to simply mortgage or sell a life interest.
I think your junior has a view.
Your junior. Trying to give you this.
It's too young to be an expert on 1925.
Spending too much time in the library. In fact, I'm told that there had been a mortgage of the life interest. So we can see, this is page 132 of the bundle.
Halfway down. 7th of June 1894.
Yes.
Thank you.
So perhaps it wasn't such a.
Can I just sort of confuse myself and everybody else a moment more, probably by reverting to the point that Mr. Weeks has widely renounced. There's a covenant with the vendor, his successors entitle and assigns. The vendor is Captain Forrester, not the trustees.
Yes.
So Captain Forrester dies. Now at that point, the land, I suppose, remains with the trustees, but the power of sale, well, no, this is pre-1925, so the son's life interest falls into possession. There we are. So how does the son get the benefit of the covenant?
By assignment.
Well, assignment? He doesn't need an assignment, does he? I mean, he just gets his life interest just falls into possession. There's no assignment. So how does he get the benefit of the covenant? He's not Captain Forrester. He's not the vendor.
Yeah.
And he's not an assignee. So how does he get the benefit of the covenant?
Well, that's a very good point. It may be that the words successors in title are intended to refer to successors in relation to the subsequent life interests.
Yeah.
Which I think was the submission that that Judge Matthews rejected. But that seems to me to be a perfectly proper way to look at the word successors in title.
And with Hutchins, it's.
Yes,
I noticed 1 o'clock. I anticipate you've got a little more to do, not least because we've taken down a number of alleyways.
But thank you. I may have a little bit of further time after lunch.
Yes. How long do you think you're going to need, just so that Mr. Moffat doesn't start feeling nervous?
20 minutes. Thank you.
Very well. Yes, Ms. Moffat, you can cope with that, can you?
Yes, I can.
Very well. Thank you very much. Just after 2, please.
All right.
Yeah. Love to hear that. No, it's all right.